Our final case of the morning will be Donald Brown versus Miller. How much time would you like for rebuttal?
3 minutes, please. Thank you.
Did you say 3 months?
3 minutes. It's been a long morning. 3 minutes, please. Good afternoon. May it please the court, my name is Elliot Kula. I'm here this morning with my colleague James Cheek, and we together represent the appellants in this case. Bill Miller was the trustee and a lifetime beneficiary of the Eleanor Miller Trust, a three-part trust established for Mr. Miller's benefit by his wife, and in pertinent part for his benefit, because there were other parts to this trust that were established for the benefit of the children. There's two provisions, distinct in structure and clear in purpose, that are relevant for this morning's discussion. They're at issue. And the arguments adopted by the trial court, as urged by the appellees, depart materially and substantially from the provisions. And I'd like to be able, for the court's de novo review, take a moment just to read those provisions because they are so critical. The first is a lifetime access, and that's beyond any health and maintenance provision that is within the trustee's discretion to provide for Bill Miller. And that provision states that the trustee shall pay to my husband, that's Bill Miller, such additional amounts as he may from time to time request. The trustee is a functionary in this provision. There's no discretion. Request is made, payments made. The second provision that's relevant for purposes of the discussion this morning is the testamentary access to the money in the trust. And that states that the trustee shall pay over and distribute the then remaining balance, if any, to such person or persons as shall be appointed by Bill Miller in his last will and testament. Otherwise, the balance that's left would revert to Tom Miller as a contingent remainder, if any shall remain. I'd like to talk about the testamentary provision first. I think it's significant and proper to begin with that for several reasons. First of all, it was executed earlier in time than the 2002 withdrawals, for what that's worth. Second, it establishes Tom Miller's position in our discussions this morning, which is that he's a contingent remainder. If anything's left at the end, he gets that. So that's his positioning in this case. And the third thing is that it's potentially dispositive of this case, because if the court were to determine that the testamentary disposition was proper under the trust, any lifetime transfers would be unnecessary to each, because any money would revert back into the Bill Miller's estate and then would come back out through his testamentary disposition. So Bill Miller provided under the power of appointment that we just read to, that the trust would, any remainder in the trust would be distributed to the Eleanor and T.W. Miller Foundation. Now, Tom Miller argued below, the trial court adopted that argument, that a corporation is not a person, the foundation is a corporation is not a person, it had to be distributed to a person. And
but you'll acknowledge that there's a fruitful field of law that acknowledges that a person and a corporation is a person.
A corporation is a person.
So why are we quibbling about that?
We think there's no quibble about that. The trial court found otherwise, though, and we take issue with that. Foundation is a corporation is a person. The distribution to the foundation is entirely proper, appropriate. The trial court was wrong on that. So then moving on to the lifetime transfer. The lifetime withdrawals. Now, Bill Miller exercises the power he has as a beneficiary, and again, it still comes down to the very plain language of the trust.
What does time to time mean?
Time to time is an expansive provision. It's not anything intended to restrict. It's expansive. It means you don't have to do it in one time. You can do it in many times, or you can do it in one time. Now, Tom Miller argued to the trial court, and the trial court adopted that argument again, that it couldn't be a single, from time to time, and it couldn't be a single wholesale withdrawal that depleted the trust. It's a slight refinement, actually, from the argument that they made below. Below, the argument was that it was a single transfer. It seems to have evolved a little bit.
Your reply brief and the trial judge's order and their pleadings indicate that there had been a prior transfer from this trust to your client's trust of like $400,000, $500,000?
There is something in the complaint suggesting about the $420,000 withdrawal. It does come up in their papers in summary judgment. The trial court does reference it, but for some reason the trial court disregarded that and didn't follow up on that.
Well, but is it in the record? I mean, in other words, if we were to write, in making our decision, can we find from the record that there had been a prior conveyance before this $7 million conveyance?
We think that there is. The $420,000
But does the record
in their
reflect it?
complaint.
Does the record reflect a transfer of money from this particular trust to your client's trust at an earlier date?
There is the reference to the earlier $420,000 withdrawal. Admittedly, the record is not fully developed.
Is it only in the complaint, or is there some testimony on the issue?
Well, this case went off on summary judgment.
Right, but prior to summary judgment, was it, someone's deposition or affidavit, or is there?
There is reference to it in a deposition. I'm reluctant to go as far as Your Honor is asking because there was motions in the middle of the briefing to relinquish jurisdiction to further develop that based on testimony in the depositions. And that motion was denied. So I don't want to go.
Was it alleged in the complaint?
It was alleged in the complaint there was earlier withdrawal.
And was that portion of the complaint admitted?
Yes, the whole complaint was admitted. And the reference to the $420,000, which we also reference in our initial brief, is at page 6 of the complaint, which is in tab 1 of our appendix and footnote 4. It says, plaintiff not only complains about the 2002 transfer and the third codicil, but also about other withdrawals of principal made by Bill Miller from the Eleanor Miller Trust, totaling approximately $420,000.
Right, but in the complaint...
I'm sorry, that's in the order. It's
right,
in the
but
order.
in the answer to the complaint, did you do a general denial, or did you admit that or deny that as far as the prior transfer?
It was, let me get to it in the complaint first.
Actually, we'll look it up.
I'll come back to that on rebuttal and give you the specific site to that. But the $420,000 is clearly referenced. It is referenced in the summary judgment order. But again, I don't want to go too far into it beyond that because of the motion practice, and I don't want to incur any other problems. But the problem with their argument from time to time, which is that it can't be a single wholesale withdrawal, setting aside for the moment that it's factually potentially wrong, although everyone has been arguing it that way. But it seeks to impose, without any basis in the trust agreement, that there's a quantitative limitation and an intermittent requirement, and there's just no support for that in the trust language. Again, the trust language is intended to be expansive. The trust language was intended to provide for a situation where you didn't have to make a request, singular. There could be multiple requests over time. And the argument actually derives quite clearly in their brief and in the papers in the trial court from a misplaced concern for remaindermen, for whose benefit this part of the trust was not drafted, not established, and based on concern for imposition of some sort of fiduciary duty on Bill Miller in the exercises of his power as a beneficiary. Very strange to be talking about a beneficiary's fiduciary obligation, because that's a trustee issue. What they're trying to create here is some sort of trustificiary where the beneficiary has trustee fiduciary duties, which just doesn't exist, and there's no legal authority for it. They attempt to find legal authority for it in the Fleck-Rubin case, second DCA case in 2006. Quite frankly, we think that case is far better for us than it is for them. Tom Miller argues that the time-to-time provision in that case included an until complete exhaustion provision, which we don't have here, and therefore you couldn't completely exhaust it with the withdrawal. Well, actually, the Fleck-Rubin case turned not on the complete exhaustion provision, but on the fact that the provision there, like the provision here, was a no discretion provision. The trustee had no role to play in that. It was an absolute right to withdraw funds. So the same result should obtain here. An exercise of a power, no trustee involvement, and the withdrawal would be proper. Now, the other place they attempt to gain some leverage is in the fact that Bill Miller had this dual role because he was both the beneficiary and the trustee. True, there are cases out there, they cite to them, we acknowledge them, where when the beneficiary and the trustee are the same person, there is a heightened vulnerability, if you will. But those cases all deal with situations where the provision at issue is a discretionary provision, and then understandably so, there'd be a heightened vulnerability to the exercise of rights and powers. Again, that's not what we have here. This is an absolute right. We don't care who the trustee is in this case with respect to the lifetime withdrawals. The trustee could be Tom Miller himself, and there would be no right to deny the request. If the request is properly made, if the request is made for money that is in the trust, and if the request is for money to be paid to Bill Miller, then the trustee has no option but to grant that request. It's no different than a bank teller and showing up with a proper ID and an account number, or drawing down a line of credit. There's nothing for the trustee to do but to honor the request. And quite frankly, there's just no basis for moderating that provision in the trust agreement, which is what they've attempted to do. They want to, but they cannot elevate Tom Miller's status from an, if any, remainderment to someone who deserves some sort of fiduciary obligation. They want to, but they cannot moderate Bill Miller's absolute power, which is clear in the plain language of the trust agreement, and they want to interpose some sort of fiduciary duty on a beneficiary's exercise of an absolute power. Again, they can't do that. There's no such creature, Florida law or anywhere else in this country. There's no such creature such as a trustificiary. We talk about the Lyman case in our brief, and I refer the court back to that case. That case it's a Connecticut case, admittedly not binding, but the analysis in that case is instructive. The analysis in that case goes through the distinction between the beneficiary and the trustee and the exercise of an absolute power, and the distinction between a discretionary provision and a no discretion provision such as exists here. The trial court misapprehended these provisions, understandably so, given the way it was argued to them by Tom Miller. And the trial judge adopted those arguments, and those arguments were flawed, and the findings by the trial court in the summary judgment ruling were flawed. It diluted Bill Miller's absolute power under the trust agreement. It employed a hyper-technical interpretation of "to my husband" as precluding anything other than a cash transfer to him, hand-to-hand currency, no wire transfers, no deposits in account, and it added language to the power of appointment. That we're not talking about a person as in a corporation, we're talking about a natural person. Well, the language doesn't say natural person, it's person. With that, we respectfully request the court reverse the summary judgment and remand with instruction for the trial court to enter summary judgment for the appellees. Thank you. The fact of more than one withdrawal is admitted by the appellee in their response to the motion. Again, I was referring to that motion practice earlier on about the request to relinquish jurisdiction to further develop the record on that point, but in their response, that is an admission that's made. And I will...
Whose response?
Their response to the motion to relinquish jurisdiction to further develop that point below. In their response, they actually admit that the $420,000 is, in fact, a prior withdrawal.
Okay.
And it's admitted in their motion for summary judgment. And I'll come back on rebuttal and give you the specific page and paragraph numbers for that.
Thank you.
Thank you.
Thank you.
May
May it please the court. My name is David King of the firm of King, Blackwell, Downs, and Zender in Orlando, Florida. Tom Zender is with me, and we represent Tom Miller, the son of Bill and Eleanor Miller. In the trial court, the court found that the power of appointment was ineffective, the 2000 power of appointment was ineffective, and that the transfer in 2002 of over $7 million to close out Trust A2 violated two limitations contained in the agreement, in the trust language, and also the duty of good faith. Let me go.
Let's talk about time to time. How many transfers are required to meet the time to time, you argue, a restriction?
Right. The transfers regarding the time to time, and let me answer as I do that the question you asked before, which was what does the record show about that? A footnote to Judge Kirkwood's decision points out that about $420,000 came out of the trust before the $7 million transfer that we litigated about in the trial court. There was no argument made in the trial court that those earlier transfers affected the time-to-time argument. That was not preserved in the trial court, and that's the basis of the decision, I suppose, to reject that argument when they raised it in their reply brief for the first time.
Well, the trial court found that there was a $420,000 transfer, and the trial court found that there was a subsequent $7 million transfer.
Correct.
And notwithstanding those findings, the trial court also found that this was violative of the time-to-time restriction.
The trial court found that the removal of in excess of $7 million at one time, under those facts, violated the language. It, in fact, wrote out the language in the trust from time to time, which is a restriction, I would submit.
If it is a restriction, how many transfers are needed before it's no longer a violation of restriction? 3, 4, 5?
That is a slippery slope, and I understand that's why you're asking me that question. The only thing I can say two answers to it. One, the transfer that was made was so stark, was so excessive in emptying the trust of $7 million that certainly deals with the language of whether that would be an occasional movement from the trust.
There was no prohibition in the trust from all the funds from that subtrust to be removed. The remainderment's interest is, if any. And so if
right.
the trust can be effectively cleaned out, your position time to time means it can't be done all at once. That's the argument that you've taken. The record seems clear that it wasn't done all at once, that if you took the beginning balance and interest and you had a $400,000 withdrawal and then you had a $7 million withdrawal. Is there some law that you cite that says that it's got to be done in chunks of 3 or 5 or 10 or?
We cite Kemp versus Patterson, which was the New York case that said it should be done on an occasional basis. And that language was what I think the trial court was considering as he considered this argument.
But in that case, the trustee had the discretion to give out money time to time, whereas in this case, the time to time references the beneficiary's right to request it.
Right, and we're not suggesting under the time to time restriction that that's because of the remainderment. The argument is simply that the time to time itself is a limitation. That's what they found when they interpreted that language in Kemp. The cases that they rely on, the Lamon case, they have vastly oversold the Lamon case in their papers. The Lamon case involved totally different language, and the time-to-time language wasn't even involved in the principal reduction, which was where they removed money in the principal.
Well, Mr. King,
yes.
Will you agree that there's no limitation on drawing down that trust to 0? Okay. Well, I mean, do you agree with that?
I I agree that if it followed the terms of the trust, it could be done.
Sure.
Yes,
He had the authority to.
he had
drain
the authority
trust.
to do that, and he could. We simply suggest to you, Your Honor, that if you adopt their position, you write the time to time out of the language.
Well, if there were two drawdowns, that looks like time to time.
Right.
And I don't know of any specific,
Okay.
I'm a little skeptical, frankly, that it requires more than one time. But setting that aside, there's at least two here that we
Okay.
know of. So I guess I'm having a really difficult time understanding why, if you have the authority to drain the trust and you do it, I mean, for any reason, it doesn't seem to, it's not limited by.
No, there's certainly no reason. There's no requirement about the reason.
I guess I'm struggling with why there is any limitation on, is it Bill Miller, to withdraw that at one time if he wanted to.
Okay. I understand the
Help me
court.
with that. I'm really struggling with it.
I understand the court's concern about that. I simply, and the case law that's cited, if you look at the cases they relied on, their cases aren't time-to-time language in either Lamon or the Hoffman or the third one. If you look carefully at the language, you'll see that they have given you an incomplete indication of what the language really was in those cases. But certainly, in this situation, there were three findings the court made to invalidate the transfer.
I think we probably ought to go to the next one.
I think I probably should, and I will do that with alacrity, Your Honor. And the next one, of course, is to my husband. And that is, we submit, a pretty clear statement of where that transfer should go. It should go to Bill Miller, not to Bill Miller's trust. And the court found that Bill Miller was not Bill Miller's trust.
Well, let me ask you, just factually, is there a dispute as to whether this was a revocable trust in which Bill Miller had 100% control?
This was a revocable trust that Bill Miller had 100% control of. There's not a dispute about that, Your Honor.
Well, technically, did that transfer mean that the legal interest in that money went to the trust and the beneficial interest went to Bill Miller, the husband?
Correct, sir. And if there wasn't that separation, there would be no trust. That's Cantella, this court's decision. Back in around 1990, I think Judge Sharp wrote. So Bill Miller is not Bill Miller's trust. That's the law. And they cited, the one case they cited in their reply brief on that, the Engelke case, I guess that's the way, it's Engelke, that was a recent 4th District decision. That was a Homestead case. And that case said if somebody had a beneficial interest in property in a revocable trust, then that was enough to get the homestead exemption, but it didn't say the trust was the same as the person. Here's the determinative thing on that. Bill Miller in his trust, 4 lines after he said, Eleanor Miller in her trust, 4 lines after she said, trustee shall also pay to my husband such additional amounts, went on to say that on the death of my husband, any undistributed or unaccrued income shall be distributed to my husband's state or to such other party, including any trust created by my husband during his lifetime.
That could include non-revocable trust, correct?
That would include...
That could include non-revocable trust, correct?
And that can include a revocable trust, as it did. It included this trust, we would submit. And consequently, it appears to me from reading the trust cases that the hallmark, you can't go wrong as long as you interpret the entire trust as a whole. You try to not have any surplusage. You try to make it all harmonize with itself. And if you do that, you see that if she wanted to assign to her husband's trust the principal, she knew exactly how to do it because she assigned the income to her husband's trust if he formed one during his lifetime. So, I submit that and I might point out that if you scour the brief of the other side, you won't find any response to that argument.
Well, let me ask you something, Mr. King.
Yes.
If I might. Does anybody allege that the trust is ambiguous?
No. No.
Because it seems to me that if the trust is ambiguous in its use of the word person and trust and so forth, and my husband, it seems to me that that's going to require an evidentiary hearing to determine what the intention of the trustor was.
Well, respectfully, Your Honor, I caught that from the very first question you asked the other side, that you were concerned about that, and I'm prepared to address that, because I think
Please do.
the approach to that is simply from looking at the document as a whole.
I mean, do we know what Mrs. Miller intended by this?
We know that Mrs. Miller, from a review of the entire document as a whole, we know what Ms. Miller intended, because in the document as a whole, she refers to persons 12 times outside of the language in this particular power of appointment, 14 times if you include that. Every time she refers to persons, it's consistent with a natural person. She knows how to say foundation because she said it in the document. She talked about a distribution to the foundation in paragraph 7, paragraph 6, page 19. She talked about a distribution to the Thomas W. Miller Jr. Foundation, Inc. of Florida Nonprofit Corporation. She knew how to refer to corporations. She knew how to refer to organizations. She knew how to say, I'm going to make a gift to a person or an organization. So if you follow the mandate that I understand that you get from a bunch of cases, Pounds, Moffitt, all of them, they say the hallmark is look at the whole document.
No question about that.
And as you look at the whole document, then you see that when Ms. Miller referred to person, she wasn't referring to foundation. She knew how to refer to foundation. And she had referred to it in other places. She knew how to, the corporate form, and she referred in a very precise way to corporations.
So let me go back to the irrevocable trust, and the irrevocable trust not being her husband.
Okay.
All right. There's a point where form should take priority over substance, and some where it shouldn't. What bothers me here and convinces me why form should take precedent over substance is if that transfer went to Bill Miller for $7 million, and 60 seconds later he endorsed that check to Bill Miller Trust, you'd agree that's fine. And so that's what worries me, is that if he had done that 60-second in-between step, that argument of yours disappears. But because he didn't, he loses. So I'm worried about the form versus substance here, and why should we give precedent in this case to the form?
I understand that concern, and you're exactly right from the standpoint that if Bill Miller had transferred, if the trust, Bill Miller as trustee, had transferred to himself, he would have met the provisions of the trust. But Judge, a trust is a technical document. The language of the trust is the substance of the document. It's not the form that just can be ignored because we didn't do it right, we didn't follow the terms of the document. It's the substance of a trust. And if there's any document that you're going to follow the language of the trust, it would seem to me that it would be a trust document. That was compelling, I think, to the trial court, and I hope it will be compelling to this court when you look at the document as a whole. And the other side never wanted to do that. They didn't do it in the trial court, and I doubt they'll do it here. They certainly didn't say anything about it in their briefs, because when you look at it as a whole, you see that as far as trust is concerned, she knew how to give them the right to take it in the trust. She just did it 4 lines below where she didn't do it for principle. So I think as lawyers and judges, we have to look at that and consider that that is intent, and that reflects what the testator intended to do as that document was drafted. And now, later, years after her death, after that was formed, we can't look back and say, well, that really isn't very convenient. Let's just write that language. Either we write the language out of the income part, or we add the language to the principal part. And that seems not just merely a matter of form. That seems like a matter of substance, that because we're now doing what every court I've read about regarding trust say you can't do, which is rewrite the trust to comport with a result. Still worried about Judge Monaco here on this person issue, and I'd like to go back to that and talk just a little bit more about that, because as I indicated, it's sprinkled all through this trust, the language. I think that's the first approach you take. You look at that and you see what the testator said. What did they say in response to that? Again, they don't say anything. In the reply brief, they said the premise is revealing. We began by imposing modifier natural, that's Miller began by doing it, which Eleanor didn't do in drafting the operative power of appointment. The argument is without merit in any event. Well, you know, when you don't really have an answer, you say the argument is without merit. That's a good, convenient way to do that. They want to talk in terms of dueling dictionaries and say that they're different dictionary definitions of personhood, and they are, but really the way you solve that is just look at the document. Read the document itself. Also note that the powers of appointment are different. There are 3 different powers of appointment. This is the most narrow of those 3 powers of appointment. That is the one that they wanted to move this to the foundation in. And finally, they argue about the concept of the foundation having personhood. And Judge, you're exactly right. There is a plethora of law where you can find cases that say, like under the RICO Act, as they cited a couple of RICO Acts. Well, corporations are persons. The Civil Rights Act, counties are persons for the purposes of those. And as they pointed out, from a constitutional and statutory analysis, you can import definitions, but the definition of person in this trust is what you find in the trust. I would submit to the court.
But Mr. King, you and I both learned in law school, you were probably awake at the time, that that we could call these people, we could have used the term natural person, and that certainly would have solved the problem.
It would have solved the problem, but it would have made my argument better and clearer today.
Yeah, for sure. And we also have learned that corporations are considered persons for many, many different reasons, not just RICO and whatever else, for a whole lot of other reasons. But they're not natural persons.
But you need to consider the context in which you're talking about. And the first, I would submit to the court that the first place you go trying to figure out what was meant by the term person is the way the term is used in the document. That's, I think...
I tend to agree with you. That's exactly where you go initially. Yes.
And I think when you do that, Your Honor, you will come to an absolute conclusion that the way this was used in the document meant Eleanor Miller knew exactly that she was dealing, when she was using the term person, she was talking about a human being. She was not talking about a corporation, an organization, or a foundation, because that's what she specifically referred to in numerous ways, and even perhaps more revealing, she referred to it in terms of person or organization. In other words, in the same sentence, she understood that person was not organization.
If it'll ease your mind, I understand the argument entirely.
I'm sorry, sir. That's that speak louder, approach that some of us take. And so let me just review the bidding here then. There are 3 reasons that the transfer in 2002 was ineffective. Time to time I'm struggling with. But to my husband is solid, I would submit to the court. Because if you don't agree with that that's a limitation, then you write the language that she put 4 lines below right out of the document. The third thing the court was concerned about was good faith. In other words, and that's the fact that even with an unlimited discretion, you can find it in the Messler case, even in the case they love so much, the Lamlin case. It talks, and that was a case that was purely a naked request, if you look at it carefully and see, because it was just at the request. We give you the principle if you request it.
Do you think 737-403 applies?
737-403 applies.
This case?
Yes, I think it does because of the fact that he was the trustee and the beneficiary. There was a conflict that even Lamon recognizes, and as a consequence of that, it was appropriate for the court to do what he did, which was to find that the transfer was invalid, and since the power of appointment was not effective, the money's got to go back to the Ellen Miller Trust, where it remains in lifetime in trust for Tom Miller.
All right, Mr. King, your time's up. Thank you very much.
Thank you.
Just before I begin, I want to give the cite to where the reference is to the $420,000. It is in the summary judgment motion that they filed. It's in our appendix at tab 9, page 2. It's in the complaint, which is in our appendix at tab 6 at page 8.
Yeah, but I looked at the answer, and apparently that was denied.
Yes.
Yes. So it's mentioned in the complaint, but denied by the other side.
There was no satisfactory answer to how many transfers would be enough transfers. There was no satisfactory answer to how much at one time would be satisfactory or inappropriate. They just resort to the fiduciary duty of the trustee. That has no place in this case, and respectfully, 737-403, no application to this case, because that involves a conflict in the trustee. Trustee has no role in this case. The issue here has no application to the trustee. Agreed, we read the trust agreement as a whole, but we can't be sloppy about it. We can't slip and slide between person, the testamentary provision, and my husband, which is the lifetime transfer. Let's be careful not to be sloppy when we're reading it. There's no ambiguity. Everyone agrees there's no ambiguity. We're going to look at the plain language. We're going to look at to my husband. My husband is Bill Miller. Sure, Bill Miller is not Bill Miller's trust. Sure, Eleanor Miller was not married to Bill Miller's trust. But it was a vehicle for conveying the money. It's no different than putting it into a bag that has Bill Miller's name on it.
Do we have to read the trust strictly? Or can we do it liberally? Much as you would look at a constitution strictly or liberally?
I think we look at it like we would look at a contract. We look at the plain language, and we apply the plain language. To my husband means it has to go to my husband. If it goes to an account that he fully controls, or if it gets deposited into a bag that's got his name on it and it's handed to him, that's enough. It doesn't need to be a hand-to-hand transfer of currency. To person, not natural person, could contemplate a trust. A foundation. A foundation is a corporation. A corporation is a person. That's a proper transfer. Agreed, the intent comes from the plain meaning. There's confusion here because of that sloppiness of slipping between person.
Whose sloppiness?
In the arguments made to the trial court and in the briefs filed in this court. There's a slipping and sliding between to my husband and person and trust and foundations. The language in the provisions is clear. That's why I wanted to begin by reading the language in the provisions. If we go back to that language, we see it's clear. As my husband is entitled to withdrawals at his request, in addition to any maintenance that is to the discretion of the trustee, and those withdrawals shall be paid to him. His bank account, wire transfer, in an envelope with his name on it, all the same.
Is it slipping and sliding to have that check go to Bill Miller's trust rather than Bill Miller individually?
Well, when it's
It would be easier if we didn't have to deal with that issue.
in a revocable trust, which is no different than a bank account, and agreed that it's 100% within Bill Miller's control. How is that any different than, I would submit, putting it in a bag with his name on it? How is it any different than a wire transfer? Their argument
if it goes in a bank account, he has both the legal interest and the equitable interest. If it goes in a trust, he only has the equitable interest. The trust has the legal interest, correct?
That's correct, but it's still
There is a difference between a bank account and a trust.
And
correct.
Is there an explanation for why Mrs. Miller used different terms at different times? Why she would use person in here and specifically define a corporation or a trust in other locations. Do we have any inclination about, or any indication about why that happened?
We could speculate.
Yeah, we don't want to speculate.
There's no indication, there was no evidentiary submissions on that. But if you go through the trust, sure, there's a reference to named persons, sometimes there's reference to persons, sometimes there's company or other persons. So there's inconsistent use of the language. But when you go through the document, there's certainly at least some indication favoring an interpretation that named person is used. In this case, person is used, not named person, not natural persons. We can't slip those language, those qualifiers in there.
All right, thank you. Time's about up. Thank you both. It's an interesting and well-argued case.
Yes, very, very well argued.